we can get started.
Thank you. Good morning. Before we start the webinar, I'd just like to introduce myself, John Murphy. For the folks who do not know who I am, I'm EMA's new first executive director. I just want to mention our next event real quick, which will be a tour of the Connecticut Center for Advanced Technology, CCAT's Advanced Technology Center in East Hartford. It'll be held on March 3rd from 3 to 4. And we're also looking at doing a debriefing session, happy hour, after the tour at Bear's Barbecue in Hartford. So it is on the website. Please look into registering for that event. And for the manufacturers on the webinar today, if I have not met with you, whether as a member or if you're not sure you're a member of EMA, please feel free to reach out to me. I'd love to come down, see the facility, your facility, and talk more about the benefits of being a member of EMA. I just want to thank you. And I'd like to now turn it over to Kylie Varga from Westminster Tool. Kylie?
Hi, everyone. Thanks so much for joining us. Today, we are very lucky to have Jessica Vargas from the Connecticut Paid Leave Authority with us today. The Paid Leave Authority provides Connecticut's workforce with access to paid family and medical leave benefits by offering tools and resources, just like today's webinar, to administer this new program. And as I mentioned, Jessica Vargas is going to be presenting. There's no relation between the two of us, just a similar last name. She is the Chief Marketing and Communications Officer at the Connecticut Paid Leave Authority, and she has been with the organization since January of 2021. So Jessica, happy to turn it over to you. I think one of the things that I was really excited about is that, you being able to share some of your experiences in the past about 6 to 7 weeks or so since the program has really gone live. I think that's going to be helpful. And yeah, just really looking forward to today's presentation.
Well, thank you so much, Kylie, and John and Sheila. Thank you for having me here today to talk about Connecticut Paid Leave. So I have a presentation for you, and as we're going through, I will also share some information about kind of what we've experienced since we started accepting claims in December, and then since the benefit payments became available, which started on January 1st. So as I'm going through, if you do have any questions, if you would put them in the Q&A using the Q&A feature at the bottom of the screen, that way I can make sure I get to all of them. Sometimes if they're put into the chat, they can get buried if there are other things going in there. So please do put this in and I will make sure I get to all of them at the end. And then just as a note, we are recording this webinar, so you will receive a copy of the recording as well as a copy of the deck probably within a week or so after today. So with that, I will share my screen and we'll get started. All right, so the focus of the presentation today is the Small Business Owner's Guide to Connecticut Paid Leave. What we're going to talk about is just a bit about the Connecticut Paid Leave Authority. And throughout the presentation, you'll hear me talk not only about Connecticut Paid Leave, but also about FMLA. If you're a smaller employer, meaning less than 75 employees in Connecticut, you might not be familiar with FMLA because prior to January 1st of this year, it only applied to businesses with 75 or more employees in the state. The reason that I'll be talking about it is that it's very closely connected to Connecticut Paid Leave, even though they are two different laws. And so I'd really like you to keep that in mind as I go through, simply because if an employee applies for Connecticut Paid Leave, it does not necessarily mean that they will have job protection under FMLA, and vice versa. If they apply for FMLA, it doesn't automatically mean that they'll have income replacement. So this will make more sense as we go through the presentation, but I just wanted to put into context for you why I'll be talking about FMLA as well. We'll talk about the qualifying reasons that someone can apply either for job protected leave under FMLA or income replacement under Connecticut Paid Leave. We'll talk about what you need to know about both CTPL and FMLA, and then how you implement them in your workplace. And of course, we'll leave you with some additional resources where you can get more information, as well as resources you can share with employees, and we will answer your questions. Just a quick overview. Kylie actually already shared a lot of this information in her introduction, but the Connecticut Paid Leave Authority, we're a quasi-public entity, and we oversee the Connecticut Paid Leave Program. And our mission is to provide a pathway to accessible paid family and medical leave benefits and to empower everyone who's touched by the program with the tools that they need to understand how it works and how to navigate it. A couple of key dates, starting January 1st of 2021, that was when the statute required employers to begin deducting 0.5% for contributions to the Connecticut Paid Leave Program. Those contributions are due quarterly, so the next upcoming due date is January 30th of 2022 for first quarter, because there is a 30-day grace period. And on January 1st of this year, the benefits actually became available for qualifying reasons. Now, let's first talk about FMLA. So FMLA stands for the Family and Medical Leave Act. There is both a federal law and a Connecticut law, and both have been around since the 1990s. Now, these laws provide job-protected time away from work for certain qualifying family and medical reasons. However, the leave under FMLA is unpaid. There are some employers that will provide income replacement, either through, for example, a more common example might be paid maternity leave or paid parental leave, or employers may allow their employees to use their accrued PTO in order to have income replacement while they're on this job protected leave. However, there is no requirement under FMLA that employers provide any sort of income replacement. Now, as I mentioned, and I'll get into the specific changes later on in the presentation, but Connecticut FMLA changed very significantly on January 1st of this year, and it now applies to many, many more businesses than it did previously. Now, Connecticut Paid Leave, we often use the acronym CTPL. I like to think of it as kind of the flip side of the coin. So whereas FMLA provides job protection, Connecticut Paid Leave provides income replacement for eligible employees. The reasons that folks can apply for either Connecticut Paid Leave, income replacement, or job protection under FMLA are the same reasons. So if an employee comes to you and says that they are going to be out on FMLA, it's very likely that they may qualify for Connecticut Paid Leave as well. But Connecticut Paid Leave in and of itself does not provide any job protection. Let's talk about qualifying reasons. There are 6 reasons that are considered qualifying reasons or qualifying events for either job protection under FMLA or income replacement under Connecticut Paid Leave. The first is medical leave. So medical leave is leave that a worker would take to receive treatment for or recover from their own serious health condition. Serving as an organ or bone marrow donor does qualify as a serious health condition, as does pregnancy. The second type of leave is bonding leave, and this is leave that a worker can take to bond with a new child that's entered their home through birth, adoption, or foster care. Both mothers and fathers may take bonding leave, and it can be taken at any time during the 12 months immediately following the child's birth or placement in the home. In the case of adoption and foster care, bonding leave can also be used for pre-placement activities that the adoptive or foster parent needs to attend to prior to the placement. The third type of leave is called caregiver leave, and this is leave that an employee would take to provide care for a family member who's experiencing a serious health condition. And we will talk about who counts as a family member under the Connecticut FMLA and Connecticut Paid Leave laws. The next 2 types of leave are specific to military. There's military caregiver leave, which is leave that an employee could take to care for a family member who is injured during federal active duty in the armed forces. And then there's something called qualifying exigency leave. And this is leave that an employee could take if they are notified that their spouse, child, or parent has been called to federal active duty. So an example of this could be if you have a couple where the spouse is the military member and they're the ones that primarily are providing child care for the couple's child. If that spouse is notified that they're going to be deployed, the employee could use qualifying exigency leave to take a bit of time off from work to make alternative child care arrangements for when their spouse is deployed. That's one example of how qualifying exigency leave could work. And then the last type of leave is family violence leave, and this is under the Connecticut Family Violence Leave Act. This is leave that a worker who's experiencing family violence can take for things like seeking medical care or counseling, obtaining services from a victim services organization, relocating, or attending court proceedings that are related to the family violence. There are up to 12 days in a calendar year available under the Family Violence Act. And I will talk about the maximum lengths of leave or benefit time available for the other types of leave in just a few minutes. Now, in going through a lot of those leaves, you heard me mention serious health condition. So a serious health condition does have a legal definition under the Connecticut paid leave statute. And so in order for something to qualify as a serious health condition, it has to meet one or more of the following criteria that I'll go through. The first would be that due to the condition, the person needs to have an overnight stay in a hospital or another healthcare facility. The second would be that the condition causes incapacity of more than 3 days and that the person seeks treatment within the first 7 days of that incapacity, that it requires continuing treatment under the care of a healthcare provider. So that might be prescription medication, for example, and the individual is required to return to their doctor for follow-up within 30 days. The third would be that the condition causes a period of incapacity because of a chronic serious health condition, and the individual sees their healthcare provider at least 2 times per year for that condition. The next would be a permanent or long-term condition for which treatment is no longer effective. So examples of this might be the end stages of cancer or Alzheimer's disease. The next would be a condition which requires restorative surgery after an accident or another injury, in which if the person did not have that surgery, they would be incapacitated for more than 3 days. So this would be, for example, surgery for a broken bone. And then lastly, as I mentioned, pregnancy and prenatal appointments can be covered as a serious health condition in relation to pregnancy as well. Now, understandably, we have gotten quite a lot of questions about COVID and if COVID is a qualifying reason for someone to seek benefits under Connecticut paid leave. The answer is that having COVID or being diagnosed or exposed with COVID in and of itself does not meet the criteria of a serious health condition. And I'll use myself as an example. So I had COVID about a month ago. I did not see my doctor. I did a home test. Wasn't feeling great, but I was able to manage at home with some over-the-counter medications and rest. So a case like that, I would not have been eligible for Connecticut paid leave benefits. However, if the person experiences one or more of those criteria of a serious health condition that I just reviewed, so if they end up in the hospital overnight, or if they do in fact see their doctor and their doctor decides that they need prescription medication and wants to see them back again in a week's time or something like that, then it's possible that they could receive benefits under Connecticut paid leave because they would then meet the criteria of a serious health condition. As with anything, the person would need to be able to provide medical certification from their healthcare provider that attested to the fact that they met this criteria of a serious health condition. So one thing that we've been experiencing, especially over the past several weeks, is an influx of applications for paid leave benefits because of COVID. And it's making up, I want to say, somewhere around 20 to 25% of the claims that are coming in. We're trying to do a lot of education around what you see on this slide, just so that people understand that just because they have COVID and they had to miss a week of work because their employer says you need to quarantine for 5 days pursuant to the CDC recommendations before you can come back or something like that, that does not necessarily qualify them. So we are, because of that volume of claims coming in because of COVID, we are experiencing a little bit longer processing times for claims than we would like. But again, we are trying to do a lot of education. We've put information on our website so that if someone goes to submit a claim, right at the top of our homepage, it says, if you're thinking of submitting a claim because of COVID, make sure you read this first. So just wanted to address that. As Kylie said, she was interested to hear what our experiences have been. So COVID and that surge in cases has certainly added an additional element that we weren't necessarily expecting, but that we are addressing. So when I talked about caregiver leave, you heard me mention that we would talk about the definition of a family member. So under federal FMLA versus Connecticut FMLA and Connecticut paid leave, there is a different definition of who qualifies as a family member. Under under federal FMLA, the only familial relationships that qualify are a parent, a spouse, a child under 18, or a child over 18 who has a disability. So someone taking job protected leave under federal FMLA can only take caregiver leave for those specific relationships. Now, under Connecticut paid leave and Connecticut FMLA, the familial relationships that are recognized are a parent, a spouse, a child of any age, a sibling, a grandparent, a grandchild, or an individual related to the employee by blood or affinity. So what does that mean, related by affinity? Related by affinity essentially means that if the employee can show that they have a significant personal bond with someone who it reflects one of the family relationships that was listed, even if it's not a biological or legal relationship, they can potentially take caregiver leave to care for that person. So what are some examples of what this might look like? One would be an aunt or an uncle who relies on the worker for unpaid care. And the relationship that you see between the worker and the aunt or uncle is more like what you would normally see between a parent and a child. That could be considered relationship by affinity. A common example might be an unmarried couple who live together, have children together, share finances. So they have a spouse-like relationship, but they are not legally married. So therefore, they would be considered related by affinity because the state of Connecticut does not recognize common law marriage. So under federal FMLA, that couple could not take job protected leave to care for each other if one became sick. But under Connecticut FMLA, they could take leave for that significant other and potentially receive Connecticut paid leave benefits. So now you kind of have the basics about Connecticut paid leave. What do you need to know? So the first thing is, are you covered employer under Connecticut paid leave? Almost all employers who have one or more employees in the state of Connecticut are covered under Connecticut paid leave. Non-unionized employees of the state of Connecticut are also covered. There are a few exceptions who are not considered covered employers, and therefore their employees are not eligible for benefits. And those include the federal government, municipalities, and local or regional boards of ed, unless their unionized employees collectively bargain to participate, non-public elementary and secondary schools, railroads, the governments of other states, and other sovereign nations. Sole proprietors and independent contractors. So sole proprietors and independent contractors are not required by statute to participate in the Connecticut paid leave program. However, they can opt in and enroll if they would like to participate. If they do enroll, they'll have to stay in the program for at least 3 years, and they contribute at the same rate as everyone else. So they contribute 0.5% of their self-employment earnings. There is a waiting period, if you will, where a self-employed or sole proprietor who enrolls in the program does have to make contributions for 3 months before they can put in for a claim. And that's just to prevent someone who was not enrolled and then knows that they have, for example, a surgery coming up and wants to enroll just to be able to use the benefits for that surgery that's happening a week from now. If someone is a sole proprietor and they choose not to opt in for themselves, but they do have employees on their payroll, then they do have to register their business and remit contributions on behalf of their employees. So even if they're not participating for themselves, they do participate for their employees. And if you receive a W-2, then you are considered an employee under the law and you must participate. And this is true even if you're the owner or an officer of the company. Next thing to know is what makes a worker eligible for Connecticut paid leave. Before I go through this, I want to just draw your attention to the bold at the bottom of the slide and just let you know that you as the employer are not responsible for making the eligibility determination for Connecticut paid leave. I'm sharing this with you so that you're aware of what the criteria are, but we at the Connecticut Paid Leave Authority work with AFLAC, who's our third-party claims administrator, and we look at the data and make the determination if the person has met this criteria for eligibility. So I just don't want anyone, trying to memorize this or write it down or worry about figuring it out, but it is important for you to know in case an employee comes and asks you. So the first is a minimum earnings criteria. The worker must have earned at least $2,325 in the highest earning quarter of the first 4 of the 5 most recently completed quarters. That can come from one or more covered employers in Connecticut. So if you have part-time workers, if they have earned at least that $2,325 between your business and another covered employer that they work for, then they would meet this criteria. This applies to full-time, part-time, seasonal, per diem. There's no requirement that the person has to be a full-time employee. So to illustrate this, if you take a look at the chart that's in the middle of the slide, this is for claims that are being made now. So for the time period of January 1st through March 31st, this first quarter of 2022. We are looking back at the quarters that you see in green. So fourth quarter of 2020, and then quarters 1, 2, and 3 of 2021. Quarter 4 of 2021 would not qualify for the claims that are being submitted now. So we look back at those time periods in green, and if the employee earned at least $2,325 in at least one of those quarters, then they would meet this requirement. The second criteria is that they're either currently employed in Connecticut by a covered employer, or if they're not currently employed, that they were within the 12 weeks immediately preceding their claim for benefits. And of course, if they're a sole proprietor or self-employed individual, they must have opted into the program. The next thing to know is, how do the benefits work? So workers who receive minimum wage or who earn minimum wage will receive 95% of their wages, of their base weekly earnings. So minimum wage is $13 an hour. If you have an employee who works 40 hours a week at $13 an hour, that equates to $520 a week that they're earning. They receive 95% of that, which is $494. That's a pretty straightforward calculation. Workers who earn above minimum wage have a different calculation. I'm not going to go through it because it can be very complicated. Again, not something that you have to figure out how to calculate. This is something that we calculate. But the important thing to know is that in all cases, benefits are capped at 60 times the minimum wage, and that's $780 per week currently. So no matter how much someone makes, they cannot get more than $780 per week in Connecticut paid leave benefits. An eligible worker can receive up to 12 weeks of income replacement based on the medical necessity for all leave reasons, and that does include military caregiver leave. The only exceptions to this are that with family violence leave, there are only 12 days of the 12 weeks available for family violence reasons. And it's possible that there may be an additional 2 weeks on top of the 12 for a patient who is experiencing incapacitation during pregnancy. Now, if someone comes to you and asks how much they can expect to receive, we do have a tool on our website called the Benefits Estimator. It's right on the claims page, and what the person would do is put in their pay period frequency and their gross earnings and click estimate, and they will get an estimation. This is not necessarily exactly what they're going to receive because, of course, there may be some employer provided income replacement to look at or short-term disability, but it gives them an estimation of what they can potentially receive. And speaking of employer provided income replacement, let's take a look at how what you as an employer provide for paid time off might coordinate with Connecticut paid leave. So one thing to keep in mind, this is a change that has just gone into effect with Connecticut FMLA, is that starting January 1st of this year, as an employer, you can no longer require your employee to exhaust all of their PTO in order to have income replacement while they're out on leave. You can still require them to use some of it, but you do have to allow them to keep up to 2 weeks of their PTO if they would like to do that. So for example, if you have an employee who's going to go out on leave and they have 4 weeks of accrued PTO, their doctor tells them that they will need to be out for 4 weeks. You can require them to use 2 of their weeks, but if they would like to save the additional 2 weeks for use later on in the year, you do have to allow them to do that. So just keep that in mind as we're going through these different scenarios. In our first scenario, let's say the worker either has no PTO to use or they only have 2 weeks and they're choosing not to use it. In that case, the worker would be eligible for the full amount of Connecticut paid leave benefits starting from the first day of their leave. That's pretty straightforward. Scenario 2, let's say the worker does not have the worker does have enough PTO to cover their entire leave. Either they're choosing to use all of it or they have enough that they can still retain those 2 weeks. In that case, the worker is going to be fully compensated by the employer, so they will not be eligible for any Connecticut paid leave benefits, and their allotment of Connecticut paid leave benefits would remain intact if they needed to use it at a later time in the year. In scenario number 3, the worker has available PTO that's equal to their regular pay that will cover part of their time out on leave. So in that case, the employer provided benefits would be used first, and then the Connecticut paid leave benefits would start after the employer provided PTO ran out. And then in the 4th scenario, the worker has PTO that is less than their regular pay. So in this case, they can receive both the employer provided benefits and the Connecticut paid leave benefits, starting from the first day of their leave, but between the two, they could not receive more than 100% of their normal pay. What happens when someone actually comes to you and says that they're going to be submitting a claim for Connecticut paid leave? Well, first of all, let's start with the contributions, just as a quick recap. So the contributions are half of 1% of FICA wages up to the Social Security contribution limit. That is $147,000. So if you have an employee that makes more than $147,000 after they contribute at that $147,000 level, they would not contribute anything above and beyond that. So that makes the maximum contribution $735 per year. The employer deducts that half of 1% from the employee paycheck and remits it to us electronically on a quarterly basis through the Connecticut Paid Leave website. We at the authority receive and reconcile the contributions. We process any over and under payments and can impose penalties for noncompliance. The Department of Labor comes into play because they can determine whether or not to allow employers to take catch-up contributions. So for example, right now, the Department of Labor has authorized a temporary catch-up period, which runs, started January 1st, it runs through March 31st. And during that time frame, employers can take an additional 1% on top of the statutory 0.5% in the event that they need to catch up because they missed taking contributions in 2021. After March 31st, that additional 1% can no longer be taken. It will revert just to the 0.5%, and any employer that wants to take additional contributions will have to get permission from the Connecticut Department of Labor to do so. Now let's talk about the claims piece. So if an employee is going to be applying for Connecticut paid leave, first and foremost, they should be notifying you that they are in fact going to be doing that. We want it to come from them. It's not meant to be a surprise to you in any way. They should submit their application in a timely fashion. And what that means is if the leave is foreseeable, that should be 30 days in advance. And if it's either emergency or an unplanned leave, it should be as soon as is practical. They can submit that application either through our website, ctpaidleave.org, or by calling AFLAC directly at the number that you see on the screen. When they do that, AFLAC will do an intake, find out what kind of leave they're applying for, and then let them know what kind of documentation they'll need to provide. So they will be responsible for getting that documentation, whether it be a medical certification from their healthcare provider, military records, adoption documents, and then they will keep AFLAC updated with their absence information and any other sources of income that they may be receiving. One form that the employee will be given when they put in their application is called an employment verification form. So they'll fill out the top part with their basic information, and then they'll provide that to you, the employer, to fill out the bottom part of the form. And that has information about their typical work schedule, any overtime, etc. Once you fill that out, you'll return it directly to AFLAC with either the email address or fax number that's provided right on the form. And in terms of any paperwork, that really is all that you as the employer need to provide in relation to the Connecticut paid leave claim. We wanted to make it really turnkey for employers in terms of any paperwork. So there's only this one form that you need to fill out. Additionally, though, you should notify the worker about your PTO policies, especially if you have a short-term disability policy. And it's really important to look at your short-term disability policy and see how it's written. Some policies say that they're the payer of last resort, meaning that the employee would need to collect any state-provided benefits and employer-provided benefits first. Some are not written that way. So we're often asked that question about, is short-term disability going to pay first, or is Connecticut paid leave? And it's not something we can answer because it's dependent on your policy. Other things you would want to let them know about are, for example, if they are taking time off for caregiver leave, maybe their child is sick, their spouse is sick, can they use their own sick time for that, or do they have to use only their vacation time? So it's important that you do have a written policy in place, because you don't want to be trying to sort of figure it out when someone comes to you. Of course, you would want to refrain from any discrimination or retaliation to the worker for using Connecticut paid leave. And then at Connecticut paid leave, and working with AFLAC, we will first determine if the employee is in fact eligible for the program based on the minimum earnings and the employment criteria that I looked at before. We'll review the supporting documentation. We'll let them know if there's anything missing. And then once we have all the details, we'll either approve or deny the claim as appropriate. When the claim is approved or denied, the employer will receive communication from us, most likely in an email. You indicate on the employment verification form if you prefer email communication or postal, US postal mail. So you'll receive notification whichever way you have specified. That'll state the employee's name, if they were approved or denied, if they were approved, the length of time they were approved for, and what their weekly benefit amount will be. We calculate and pay the benefits. The benefits are paid either through direct deposit to the employee's bank account or through a stored value card, which is essentially a prepaid Visa debit card that we would mail directly to the individual. We monitor ongoing claims, we investigate potential fraud, and impose any penalties as necessary. Now, if an employee is denied, they have what's called the right to request a reconsideration. Essentially, what that means is we at the Paid Leave Authority and with AFLAC would look at their claim again as a brand new claim. So perhaps they were denied because we were missing a piece of documentation, or their healthcare provider had been away out of the office for several weeks and they weren't able to provide the medical certification or something like that. We'll do a reconsideration where we'll look at all the documentation again, anything that might have been missing, and see if there's a different determination. However, if the person either does not want that reconsideration, or if after the reconsideration they're still denied, they can go to the Connecticut Department of Labor, and the Department of Labor will hear appeals related to the denial of claims. Now, what do you need to know about FMLA? So again, as I mentioned at the beginning, Connecticut paid leave and FMLA are two different laws, and just because someone applies for one doesn't necessarily mean that they're going to receive the other. So FMLA, just to review, Family and Medical Leave Act, this is the law that provides job protection. How do you know if you're covered under federal or Connecticut FMLA? So federal FMLA is not changing. It's the same criteria that it's been. In order to be covered under federal FMLA, you as an employer must have 50 or more employees within a 75-mile radius. Government entities of any size are also covered, including the ones that you see listed on the left side of the screen. Now, the big changes. Connecticut FMLA now applies to almost all employers who have one or more people working for them in the state of Connecticut. The only entities that are not covered under FMLA, Connecticut FMLA that is the federal government, municipalities, boards of education, non-public elementary and secondary schools, railroads, governments of other states, and sovereign nations. So if you think back to when I was talking about who's a covered employer under Connecticut paid leave, it mirrors who's a covered employer under Connecticut FMLA. What does an employee need to do in order to be eligible for job protection? Under federal FMLA, in order to be eligible for job protection, they must have been employed by the company for at least 12 months and have worked at least 1,250 hours in the 12 months immediately before their leave. Again, that's as it has been, it is not changing. Connecticut FMLA, significant changes starting January 1st of this year. An employee is covered with job protection available under Connecticut FMLA after 3 months of employment. There is no longer any hours worked requirement. There used to be, but there is not any longer. How long is the job protected leave under FMLA? Under the federal law, there's up to 12 weeks of leave in a 12-month period for all reasons, except for military caregiver leave, in which there's up to 26 weeks of leave available. Connecticut FMLA now very closely mirrors the federal timelines. So up to 12 weeks of job protection are available under Connecticut FMLA for almost all reasons. There are 26 weeks available for military caregiver leave, just like on the federal side. And as you heard me say with Connecticut paid leave benefits, there's also potentially 2 additional weeks available for incapacitation during pregnancy. Under the Family Violence Leave Act, there are up to 12 days available in a calendar year. Here's a side-by-side that shows you what Connecticut FMLA was versus what it is now. So it used to be only applicable to employers with 75 or more employees. It now applies to employers with 1 or more employees. It used to be that you had to work for your employer for 12 months and at least 1,000 hours, and that you would then have job protection after those 12 months. There's now job protection after 3 months, and there's no minimum hours worked requirement. The timeframes have changed. Connecticut FMLA previously provided up to 16 weeks in a 24-month period. That's now up to 12 weeks in a 12-month period. Special note about military caregiver leave. This is one difference between Connecticut FMLA and Connecticut paid leave. Under Connecticut paid leave, we will pay for up to 12 weeks of income replacement for military caregiver leave, but Connecticut FMLA and federal FMLA both provide for up to 26 weeks of job protection. So if you do have someone who's taking military caregiver leave, it's possible that they could have job protection for 26 weeks. Under Connecticut paid leave, 12 of those weeks would be eligible for them to receive payment. And then lastly, as I touched on previously, prior to 2022, an employer could require their employee to use all of their accrued PTO while they were out on leave in order to have income replacement. Now you do have to allow the employee to keep at least, to keep up to 2 weeks of their accrued PTO to use later in the year. Implementing FMLA. So now many businesses who did not have to consider FMLA previously now do. So what does that process look like? The worker would come to the employer and let them know that they need to take time away from work. They would submit an application to the employer. So this is Connecticut paid leave does not have anything to do with FMLA claims. They would provide the employer with supporting documentation, and they would comply with the employer's attendance and call-in policies. As the employer, again, you should have an established leave policy, including rules about your PTO usage. You would process the leave request, monitor the leave usage, manage the worker's return, and refrain from discriminating. So if they come to you, they say, hey, my doctor told me I need to go out and have surgery. I'm going to be out for 5 weeks. That should trigger for you. This sounds like it could be FMLA. And then you would say to the employee, okay, in order for you to have job protection, here's what I'm going to need from you. And I'll show you where you can find all the different forms and things like that from the Department of Labor. So Connecticut Paid Leave Authority, we don't have any official responsibilities. Connecticut Department of Labor oversees everything related to Connecticut FMLA. But we do provide this training because, as I think you can see by now, it would be really tough to talk about Connecticut paid leave without talking about Connecticut FMLA because they are so closely intertwined. And then on the federal side, the Federal Department of Labor oversees federal FMLA. So here's what the process looks like. The worker notifies you that they need time off from work. They don't have to use the term FMLA. So as in the example that I gave, if it sounds like a reason that could be covered, then you should go through this process to see if they're going to be eligible for job protection. Ideally, they're going to tell you 30 days in advance if the leave is foreseeable, as soon as practicable if the leave is not foreseeable. Again, applying for Connecticut paid leave benefits is not the same thing as applying for FMLA. So the employee really does need to do both, because if they apply for Connecticut paid leave and they're approved, but they don't ever talk to you, then they're not going to have job protection. And of course, they would want job protection to be able to come back to work after their leave was over. The employer determines if the worker is eligible for Connecticut FMLA and notifies them of what documents they'll need to provide. The employer has 5 days after the employee comes to them to notify them if they're eligible and to provide what's called the notice of rights and responsibilities. So this is not the actual leave approval. This is just you saying, hey, yes, the reason that you told me you're going to be out is one of the qualifying reasons. And yes, you have met the eligibility criteria, which is that you've been employed for at least 3 months. Then the worker provides all the required documentation to support the leave reason. They have 15 calendar days to give you the documents. This again could be a medical certification, it could be military orders, whatever specific forms or documents are related to that particular kind of leave. If the worker tells you they're having trouble getting the documents, you should give them a reasonable extension. Once you receive all the documents, you review them. You have 5 business days to make a decision on if they're covered for job protection. You should notify them about the PTO usage, when and how they need to call in, and whether you're going to require a fitness for duty before they return to work. The worker then reports to the employer when they actually take their FMLA leave. When they call out, they should specify that it's FMLA. And the reason that this is important is with continuous leave, so if it's all, one chunk of time, it's pretty obvious that they tell you they're going to be going out on leave and then they're out for a certain amount of time. But in the case of intermittent leave, where they might have some sort of a chronic condition that necessitates them being out sporadically, but they can't predict when they're going to be out. So one example of this might be someone who suffers from severe migraines. They don't know when that's going to affect them. So if they call in because they're having a migraine, they can't report to work, they should tell you, I'm using FMLA right now. You would track their FMLA usage to make sure that they don't exceed the amount of time that they were approved for. And then when they return to work, they are returned to their same job with their same terms and conditions. That's really what the job protection piece is. It's that they get their same job back, same compensation, same hours. You can't take someone who used to work the 9 to 5 shift and tell them that they now have to work the overnight shift in order to come back. If the worker was out for their own serious health condition, they may have some medical restrictions. And so you should consider whether there are reasonable accommodations that can be put in place that would allow them to perform the essential functions of their job. Here's an overview of some different leave laws. So we talked extensively about FMLA. There's also, of course, workers' compensation, which provides both job protection and income replacement for on-the-job illnesses or injuries. There are also 3 other laws to be aware of: the Americans with Disabilities Act and the Pregnancy Disability Act, which apply to businesses with 15 or more employees, and the Connecticut Fair Employment Practices Act, which applies to businesses with 3 or more employees. For all of these laws, leave may be considered a reasonable accommodation. So I know that's a lot of information that I just put out there. We do have some great resources on our website. We have an employer toolkit and a human resources toolkit that you can download. We also have several pieces that you can provide to your employees. So we have a paycheck insert, a RAC card, employee fact sheet. Our website is a really great source of information. We have several hundred frequently asked questions. We have videos. We do not have a call center, but we do have a contact us portal on our website. So you can go in there if you have a question, enter your information. If you would prefer to speak to someone instead of emailing, that's absolutely fine. You would just indicate that, and then one of our customer support specialists would call you to help work through that issue you are having. Everything I mentioned about FMLA can be found on the Connecticut Department of Labor website that you see listed there, the portal.ct.gov. With the /DOLUI. They have all of the forms, they have frequently asked questions, anything you might need to know about FMLA. And so with that, I will stop sharing. I'll just add a little context in terms of what we've seen so far in terms of claims. By far, the majority of claims coming in are for an employee's own illness or injury. And then the second largest bucket is either pregnancy and childbirth or bonding leave. Those are the two largest. And then there's caregiver leave, which is significantly lower on the list. But we have seen claims come in for every type of leave, including bone marrow donation, organ donation, family violence, military, adoption and foster care. So we have seen claims for all those different kinds of leave. I think when I most recently checked, we were up to, I want to say, about 16,000 claims that had been submitted since December 1st. So that's just kind of where we are right now and what we're seeing. I'm happy to answer any questions. I saw one that came in the chat. So let me just look at this quickly. If an employee has used most of their PTO for non-FMLA reasons and then goes out on FMLA, can we make them take the rest of their PTO time for this leave? So no, that's an FMLA question, but no, when they go out on leave, you do have to allow them to retain up to that 2 weeks of whatever's accrued. So if they have already used a lot of it and they're going out on leave, but they still have at least 2 weeks accrued and they don't want to use it, you cannot require them to use it. I don't see any other questions, but I'm happy to answer anything else that anyone might be curious about. A quiet group on this Tuesday morning. Can we limit the length of time someone takes? Are you talking about their FMLA time? If I'm in, meaning increments of 4 hours or more. So that really would depend on what is specified in terms of their medical certification. If it's for their own leave or for a caregiver leave, it would be specific as to whatever their doctor or healthcare provider had ordered to be a reasonable amount of time. Someone else asked, I have an employee who went out in December, was denied short-term disability. Can he now apply for Connecticut paid leave? If he met the criteria, if he meets the criteria, then yes, he could apply. Anytime he was out in December, though, would not qualify. So it's not retroactive. It would only be for January 1st and beyond. Oh, now all the questions are coming in. All right. What about an employee who works remotely for a Connecticut employer but lives or works in a different state? Residency is not a requirement for Connecticut paid leave. It's where they work. The only instance in which Connecticut residency is required is in the case of a sole proprietor. So an employee, as long as they work for a Connecticut employer, then they are eligible for Connecticut paid leave. If an employee is out on short-term disability and they exhausted their 26 weeks of short-term disability, can they apply for Connecticut paid leave? Yes, they would be able to apply. On the slide that determined eligible wages, why was quarter 5 excluded? It appeared in red. So the reason is that we have to we work with other state agencies to verify wages, and there's a delay between the end of the quarter and our being able to access the wages. So in that example, if someone was applying for leave now, meaning quarter 1 of this year, we don't yet have access to the Q4 2021 wages in order to verify. So that's why we exclude that quarter and we look back to the 4 quarters before that. So it's the 4 of the 5 most recently completed quarters. If a person breaks the FMLA into hours rather than taking a full day, will AFLAC allow this? This question is in regards to a caregiver. So in terms of, I'm thinking, John, that you're probably talking about for the Connecticut paid leave portion, right? Yes, AFLAC will allow that. I mean, AFLAC will, that in that case, it would be what's called reduced schedule leave. So when someone applies, they can apply for continuous leave, which is for a single reason, all in one chunk. That's what you might commonly see for like bonding leave or something like that. Then there's intermittent leave, which is the example I gave with, someone who suffers from migraines who calls out, but they can't predict when that's going to happen. What you're talking about is called reduced schedule leave. So if they normally work Monday through Friday from 9 to 5, now they want to take every Tuesday off, for example, because they're caring for someone who is undergoing chemotherapy, and Tuesdays is when they have to take them to their treatments. Or they normally work 9 to 5, but now they want to work from 9 to 2 because in the afternoon they go over to their mother's house to help her, because she's ill and she's undergoing some treatments. That's called reduced schedule leave. And yes, that would be acceptable. Okay, any other questions?
Jessica, there was one more. It was in the chat. It says, when determining leave, do the employees fill out federal and CTFMLA forms along with apply for paid leave?
Okay, so that's a great question. So the FMLA forms would be between the employer and the employee. So it would depend if they're eligible for both, based on first your business size, right? So if your business is large enough that you're covered under federal FMLA as well. And then secondly, the type of leave that they're taking. So for example, if they were taking caregiver leave, but it was for someone who was related by affinity, then under federal FMLA, they wouldn't be eligible because federal FMLA is only those very specific relationships that I mentioned: parent, spouse, child under 18 or over 18 with a disability. The Connecticut paid leave, it's really important to kind of keep in your head that FMLA and Connecticut paid leave are two, while they're so closely intertwined, they're two totally separate things. So Connecticut paid leave, if someone wants those income replacement benefits, they're going to come to Connecticut paid leave. They're going to fill out those forms. They're going to submit them to us and AFLAC. We're going to work through that and determine if they're eligible for payment from us. Everything FMLA is between the employer and the employee. So if the person is eligible for both federal and Connecticut, then yes, they would fill out the forms for both, provide them to the employer. The employer would decide if they qualify for either or both. And I know it's really confusing. It seems like if they're so closely intertwined, why can't you just apply for one and have it kind of cover everything? But unfortunately, that's not the way it works. So we really want to make sure that you as employers understand that when someone comes to you and they say, hey, I need to go out on FMLA, that doesn't automatically mean they're getting Connecticut paid leave. They have to specifically apply for it, and vice versa. If they applied to us for Connecticut paid leave, but they don't ever come to you and talk about taking time off and having job protection, even if they get approved for Connecticut paid leave, it doesn't mean that their job is protected. All right, last call for questions. We have a couple more minutes.
One just came into the chat. Is it better to have your policy utilize the paid sick leave once every 12 months or specific to the employee?
Is it better to have your policy utilize the paid sick leave once every 12 months or specific to the employee? I would say that really is a determination each employer should make, because you can calculate it based on a 12-month look back period or a calendar year or a looking forward period. So the employer can determine how they want to calculate it, but it should be, I think, whatever you decide, I think it should be uniform. I wouldn't do it one way for somebody and then a different way for somebody else. So I would write, if it were me, and I'm not an attorney, so please don't take this as anything legal advice, but I would say you probably should have it specified in your policy and have it be uniform for everyone. Is putting it in the handbook sufficient? I think so. I mean, we don't have, there is a requirement in the statute that beginning, I think it's July 1st of 2022, you do have to have a workplace poster about Connecticut paid leave posted, just the same way you have to have one about FMLA. But we will be creating that poster and putting it on our website for everyone once that happens. But beyond that, I'm not aware of any other specific guidelines for how you need to disseminate that information. All right, well, again, you will receive a copy of the recording and the deck. Any other questions, please don't hesitate to reach out through the Contact Us portal. We have a great team. They typically reply within 48 hours. They're really great. And if you want to talk to somebody, because we know not everybody likes going through email, just let them know that and you will get a call and they'll be happy to help you work through any issues you're having.
Jessica, I just wanted to say thank you so much. This was such a great wealth of information. And I know there's some things that I will probably go back and look at the recording and kind of process it again. And really, we just can't thank you enough for speaking to us today. And for any of our members that are on the call, if you have any questions, please utilize those resources. And also, if you would like to participate in any of our upcoming events, please check out the website, emainc.com, subscribe to our newsletter, or reach out directly to John Murphy, our Executive Director.
Thank you,
Thank you
Kylie.
for having me. It was great to be here with you all. Have a great day.
You too. Bye-bye.